intellectual or developmental disability. The Down Syndrome Network of Montgomery County mission is to empower individuals with Down syndrome, their families, and their families through the community and their families and community through education, information, public awareness, and advocacy. And so with that, I would like to turn I'm going to stop sharing and I'm going to let Opal share, our program and communications coordinator, and she's going to share her screen, and Heidi is going to introduce Ms. Calgary.
Yes, where's Ellen? Ellen, we can see you. Oh, got it. And we can't hear you either.
I was letting other people take the lead.
Oh, okay.
So
all right. So now many of you already have seen and heard Ellen speak before. And we are very, very happy to have you once more explaining to us so many important things that we need to know that are very important for the lives of our children. Ellen Calgary has been a practicing attorney for over 40 years, and she's a founding partner of the law offices of Ellen A. Calgary, focusing on family law, special education, and disability issues. She represents children and adults with disabilities to help them get appropriate services, such as special education and rehabilitation services throughout the state. Ellen also helps families through the guardianship, mental health, and healthcare decision-making processes. She's the co-editor of Guardianship and Its Alternatives, a handbook of Maryland law that you may already know. Many of you already have it on your computers. You can download it. A joint publication of the University of Maryland Francis King Carey School of Law and the Maryland State Bar Association. As we said, there will be some source pages that you can have that, see all that, and download a lot of information she's going to share with you. Ms. Calgary has a long history of involvement in disability issues in various capacities, including working for the Maryland Attorney General, advising state agencies, teaching as an adjunct professor, serving on boards, and doing presentations on all these issues for families in the school and the school system too. We are very, very honored, Ellen, to have you come to talk to us today and help us understand guardianship, its alternatives, including supported decision-making, that is the newest one. So we are ready to learn. Thank you very much. And we have this is a short introduction to Ellen, because we would be here talking all the time about the things that she has done for us. But Ellen, along the way, she's going to, as she presents, you're going to hear and learn more about this wonderful person. And she's just not a presenter, but is a friend of all of us. So that, thank you for coming again.
Oh, thank you. Oh, Ellen, before you start, I truly apologize. Heidi, that was such a lovely introduction, and we are so happy to have Ellen this evening. Just a couple housekeeping thoughts here. If you have questions, please type them in the chat. I will be looking out for questions, and Ellen, along the way, will be answering questions. So she doesn't want to wait till the end so that there are tons of questions, but because she wants to answer questions in the moment on the topics. And then also, please keep yourself on mute. Unless, of course, when Ellen asks for questions and you're unable to type in the chat and it's easier for you to speak out loud, that's fine as well. So with that, please welcome Ellen. Thank you.
Hey, good evening. Welcome to my living room in Baltimore City. I'm here in my slippers and in my wonderful home, and I hope you guys are all in your homes, and I'm here for you and want to be able to answer your questions. And the other part of my background that I think it's really important to share is that I have many family members with disabilities. I grew up with people with disabilities. My father was the national commander of the Disabled American Veterans, and everyone was welcome in our home, and people who had lots of abilities. And I also have a relative, I have a couple relatives with autism, and I have lost a brother to mental illness. So I take this very seriously and want to help in any way I can. So let's move on to the next slide. So here's what we're going to be talking about. What are the legal and ethical requirements for informed consent for adults? The less restrictive alternatives to guardianship. The reason we're going to go through those before we get to guardianship is because it's actually the law in Maryland that if there is a less restrictive alternative to guardianship, such as an advanced healthcare directive, power of attorney, and the other bullet points that I have there, you need to look to those first before you seek guardianship. We will then be talking about guardianship of the person and property. You can go to the next slide. So why do I start with informed consent? Let me tell you the rule and then I'll tell you why. So this is a rule, this is a takeaway from tonight. All adults and some minors under certain circumstances have the right to informed consent in making decisions about their health care unless they've been determined to be incapable of making an informed decision. I start with the informed consent rule because the issue of guardianship often comes up when you bring a family member, your adult sibling or your adult child, to a healthcare provider, and the healthcare provider says, oh, this person can't consent because they've got a disability. Well, we all know that the vast majority of human beings with disabilities absolutely can provide informed consent, and the healthcare provider has a legal obligation to get informed consent or informed refusal. Next slide. So here are the elements of informed consent, and this is for all of us. So every person on this call, you've got the right to informed consent. So your healthcare providers should be explaining to you what's wrong with you, the diagnosis, what they want, what they're proposing to do, the proposed treatment, the alternative treatments, including no treatment, and the material risks of the proposed treatments, including the risks of no treatments. So those are the basic elements that have to be explained to you and explained to people who may also have disabilities. Next. So as you all know, informed consent's a very personal process through which healthcare providers and patients communicate about the most fundamental values. There is no right choice for every individual, meaning I certainly have had friends or relatives who I think make a bad decision about, refusing treatment or accepting treatment, but we all have the right. That's, our right of self-determination. Speaking of which, so the theme, the other theme you should take from this evening is the important ethical principle of autonomy, preserving self-determination. So that's what all this is about. We want to make sure that every human being has the right to make decisions for themselves and feels empowered to do so. Beneficence just means doing good. Oh, we jumped ahead. The other ethical principle is non-maleficence, meaning doing no harm. And then veracity, truth-telling. So truth-telling is something that healthcare provider has a legal and ethical obligation to do, to tell you, all of those elements of informed consent and have a real discussion with you about the healthcare that they're suggesting. Next slide. And I want to have a nice shout out to Opal, who's doing a wonderful job following me. Opal is sharing her screen and putting up the PowerPoint. So yay, Opal, thank you. So informed consent must be obtained directly from the adults prior to the provision of healthcare. And that legal responsibility rests on the healthcare provider. So some of you may have seen, and I know that I've had this when I've gone to healthcare appointments with individuals who may have disabilities or may not be able to communicate. The healthcare provider will talk to the person in the room who looks like they might not have a disability and ignore the individual who appears to have a disability. Nah, that's not right. That's not what the law requires. And so it's important to get informed consent from the individual themselves. Next. So this, parents will come to me and they say, oh my God, my daughter's turning 18, you know, in a couple of months. What am I going to do if there's an emergency? We don't have guardianship, and you know, who's going to consent to healthcare if there's an emergency? And I say, oh, guess what? There's a Maryland law that says that in an emergency, healthcare providers can treat if the treatment is of an emergency medical nature, and there's nobody authorized to give consent immediately. So that applies to all of us. So if, you know, anyone here, God forbid, is in a car accident and lying unconscious on the side of the road, you can be provided emergency healthcare services, even though there's no one there to provide consent, and you obviously cannot provide consent. Next slide, please. So the other part of this is that the attending physician has to determine there's a substantial risk of death or immediate and serious harm to the patient, and within a reasonable degree of medical certainty, the life or health of the individual would be affected adversely by delaying treatment to obtain consent. So for those parents who come in and say, my daughter's turning 18, you know, once they're 18, they're able to provide the consent. But, you know, if there's an emergency, you don't have to have somebody who can provide consent. Next slide. Many people are surprised by this because a minor has the same capacity as an adult to consent to medical treatment under certain circumstances. So again, there's an emergency exception for a minor. So if your minor child has a medical emergency, they can be provided emergency medical treatment, even if parents or guardians aren't around to provide the consent for the treatment. Next slide. This is also surprising to people, is that if the child is married or is the parent of a child, they have the right to consent to healthcare. Now, keep in mind, healthcare providers still have to determine whether that child understands all those elements of informed consent. And if they don't, then they're going to need to have parents make that decision for the minor. Next. So when somebody competent, in Maryland, you are magically presumed to be competent once you turn 18 years of age. So you can make financial decisions, you can make healthcare decisions, you are in control, and no one else can make that decision unless there's been a guardian appointed, or unless you've been determined to be incapable of making a decision, and then your advanced healthcare directive becomes effective. Next. So this is a circuitous definition. This is right out of Maryland law. The definition of incapable of making an informed decision. You are determined to be incapable of making an informed decision when you are unable to understand the nature, extent, or probable consequences of the proposed treatment or course of treatment. Next slide. Unable to make a rational evaluation of the burdens, risks, and benefits of the treatment or course of treatment, or unable to communicate a decision. Now, some people's rationals is not my rational, right? So it's an incredibly subjective term, whether or not you're capable of making a rational decision. And we're going to talk about what that means. So when you're thinking about capacity, you want to think about, does the individual understand the consequences of her decisions? If you're unsure about whether they are, you look to her doctors, social workers, and or psychologist and say, you know, what do you think about the person's decision-making? Are the decisions consistent with past stated wishes? Also think about this, you might be capable of making a decision about whether or not to take antibiotics for a strep infection, but you might not be capable of understanding a complex course of treatment for a serious cancer diagnosis. So what incapacity isn't? And, you know, Lord help us all if it's old age. So I've been a lawyer since 1978. Let's hope that old age is not an indication of capacity. Eccentricity, just because you know, do things that people think are weird doesn't mean that you're not capable of making an informed decision. There are lots of highly unusual human beings in the world, which of course makes it more fun to be alive. Poverty, just because you may not have the resources or you're perceived to be, you know, lesser simply because you don't have a lot of money, that should have no bearing at all on a determination about whether or not you're capable of making your own decisions. Refusal of care and disagreement with the healthcare provider's recommendation. These are the ones that come up all the time. I have parents who come into my office and, you know, their child is now an adult child, meaning they're over the age of 18. And they say, the doctor told us we had to get a guardian. But we've been involved in, you know, Susie's medical treatments since she was born. And we've always gone in there and the doctors talked to us about this. And now because Susie says she doesn't want that care and we agree with her that we're refusing the treatment, all of a sudden the doctor says we have to get a guardian. That is not a reason to have a guardian appointed simply because you don't want to follow the course of treatment that's recommended by the healthcare provider. Next slide. So just because you can't use oral language to communicate does not mean that you're incompetent. I have lots of clients who use different devices to communicate. Some clients who use sign language to communicate. There are clients who use gestures and eye gaze to communicate. So just because you don't use oral language does not mean that you are incapable of making an informed decision. Next slide. All right, this is a big one, right? If there's a question about capacity, get help, get a second opinion. You know, examples like an older adult with dementia, many older adults with dementia still have capacity to make decisions. Dementia sometimes can be time of day, can be a new situation, et cetera, but not impact overall capacity to make decisions. Younger adults with autism spectrum disorders, you know, most of my clients with autism spectrum disorders are perfectly capable of making decisions. I did have one client who parents really thought needed to have a guardian appointed. And I, based on looking at the records, thought there was a question about that, and we talked about it. So we got a neuropsychological assessment, and the neuropsychologist agreed that this person, young man, did not need to have a guardian appointed. In an individual with an intellectual disability, so many times healthcare providers assume because somebody has an intellectual disability that they can't make decisions. That is not my experience. And so there should not be an assumption simply based on that. If there's a question, you can always get an assessment and evaluation. So I'm going to stop and get questions right now before we move on to third-party decision-making. Brooke, are there any questions that you think I should?
There was one question related, I think it was in relationship to healthcare, the difference between informed consent and legal capacity.
So, so the general rule that everybody should take away from is that we're all presumed to be capable of providing informed consent. That is the default, that if you're a human being and you're 18 years of age, you are presumed to be capable and presumed to have capacity once you turn 18. So it's, if there's a question of capacity, meaning a question of whether or not the human being is capable of providing informed consent, then you can get a second opinion, you know, and you can go to guardianship if you need to. So we'll be talking about that later. Brooke, anything else at this point?
That's it at this point.
Okay.
Thank you so much.
Sure. So here's the answer to the question is if an individual lacks capacity, informed consent can be obtained from a healthcare agent, a healthcare surrogate, or a guardian. And we're going to go through each of those next. So everybody here tonight, if you don't have one, should go home tonight, or if you're home tomorrow, and fill out an advanced healthcare directive. So this is just a document that says what you want to have happen if you're not capable of making an informed decision. You choose an agent who can make decisions about when healthcare is provided and when it's withheld or withdrawn. So the vast majority of my clients, and let me give you an example. One of my clients, a wonderful young woman with an autism spectrum disorder and an intellectual disability. And she was able to understand, we talked in my office and I said, who's helped you make decisions with your doctors through your life? And she, talked about her mother. She also talked about her grandmother. And I said, so if you can't make decisions about your health care in the future, who would you want to do that? And she said her mother and her father. And so she was able to understand that she was giving legal authority to her parents to make decisions for her when and if she was found incapable of making an informed decision. So advanced healthcare directives, a wonderful, less restrictive alternative to guardianship. Next slide. So what you can put in, and you can have a very simple advanced healthcare directive that just says, if I can't make a decision, I want my aunt Melissa to make my decisions for me. But you can also spell out things like, what do you want to have happen if you're in a terminal condition? or in a persistent vegetative state or an end stage condition. Next slide. So an oral advance directive, most people don't know about this, and I don't recommend it. I just want to tell you that the law in Maryland allows for this. So what I want you to do is everybody do a written advance healthcare directive. But if circumstances arrive and you haven't done one, the way to do an oral advance healthcare directive is it has to be made in the presence of a physician, physician assistant, or nurse practitioner, and a witness, and then your choice gets documented in your medical record, and it's signed and dated by the healthcare provider and a witness. Next slide. So who makes the decision about whether you're incapable of making a healthcare decision? Two physicians, at least one of whom has examined you within the preceding 2 hours, has to certify that you're incapable of making an informed decision regarding treatment. They have to be based on personal examination, and then if the patient's unconscious or unable to communicate, only one physician certificate is required. So this certificate that the law talks about isn't something that's actually in the statute, but some large healthcare providers, like I know Kennedy Krieger has developed a certificate that healthcare providers can use to make that certification. But any of those two physicians or one physician under those circumstances can make that certification that an individual is incapable. And if that decision is made, then your agent, the person you've chosen, gets to make those decisions. So the kinds of things that your agent would do is review and request medical records, authorize admission and discharge from a hospital, authorize or refuse treatment. And the biggie that everybody talks about is deciding whether exactly what should be happened in terms of sustaining you in terms of life support if you're in an end stage condition or persistent vegetative state. Next. So your agent can't require a healthcare provider to render medical treatment that they determine that's ethically inappropriate or medically ineffective. That is a very rare circumstance, but I wanted you to know what the law says. Next. Many people don't know that this exists. Maryland law allows for something called an advanced mental health directive. They can, just like an advanced healthcare directive, they can allow an individual to decide ahead of time what mental health services they want. And I have found it incredibly helpful. Many of my clients have mental illnesses, emotional disabilities, in addition to their autism spectrum disorders. Many of my clients with autism spectrum disorders also have anxiety disorders. And this is very helpful in having a conversation about, can you move to the next slide? So you choose your agent, next slide. And here's the good discussion that can be had, because you can talk about which mental health professionals you like, and you can put that in the Advanced Mental Health Directive. You can say, I hated when I was at Jolly Acres psychiatric facility, but I loved Healing Homes. That was the place that really helped me. You can talk about, and this one's a really important one, medications that the patient wants or doesn't want. Many of my clients have been on, during the course of their lives, 15 or 20 medications, some of which have given them really adverse reactions, some of which they just hated because they had dry mouth, some of which they hated because it just didn't work. And this is a time to kind of capture that history and put it in the Advanced Mental Health Care Directive. I find it's a good conversation starter, and it's an important way of capturing that medical history that may not be captured in other ways. Next. So practical tips for your advanced healthcare directives. Don't let them sit in your drawer. People don't look at them again. They don't know where they are. Give copies to your agents, meaning if you chose your grandparents to be your agents, make sure they have a copy of your advanced healthcare directives. Talk with them, have an open and candid conversation with your agents about your wishes. You know, they need to know, you know, I mean, God forbid our poor son, Henry, who is now 29, as soon as he turned 18, my husband and I sat him down and said, okay, do your advanced healthcare directive. And we had a conversation with him about, you know, what his wishes were. He's now happily married and his wife is now his agent, but you know, this is an important thing to talk about. It's very difficult to talk about kind of what you want to have happen if you're in a position where you can't make decisions for yourself. The other thing is review your directives on a regular basis, because grandparents may die, and so that's your agent, that's not going to work. You want to make sure you know where it is, because so many people, you know, they've done studies where people show up for healthcare and they're asked if they have an advanced healthcare directive, and they say, yeah, but they have no clue where it is. So, you know, make sure you have one, make sure it's up to date, and make sure your agent knows that they're an agent. I'm going to pause. Are there questions related to advanced healthcare directives before I move on to health surrogates?
Yes. Can healthcare directives be used in cases of dementia?
Yes. So here's the tricky thing. When the healthcare directive is signed, the individual who signs it has to be capable of understanding what they're signing. So there are early stages of dementia. So if someone is in early stages of dementia, they're probably very capable of knowing who they would want as their agent to make healthcare decisions for them. This is a situation where if you're not sure, you want to get a second opinion about whether your loved one, your family member can understand what they're signing. But, you know, very often people with dementia have moments of clarity and can really understand that, you know, they know they're going to be needing help. They know they're going to need to have somebody make decisions. And so they might, you know, probably still be capable, but that's going to be, you know, a decision. And if you need a second opinion, it would probably be from a psychiatrist, a psychologist, a neuropsychologist, a clinical social worker to really probe that. The other situation in which advanced healthcare directives would come into play is if prior to getting dementia, your loved one had executed an advanced healthcare directive at the point at which they're determined to be incapable of making an informed decision, that advanced healthcare directive would go into effect, and then you as the agent would be making healthcare decisions for your loved one. Other questions?
That's it right now. Oh,
Okay.
wait, there is one more. It just popped up.
So the document called 5 Wishes. So it's perfectly fine to use the 5 Wishes document, but you want to use an advanced healthcare directive because that is something that healthcare providers are legally required to follow. So it is in statute, it's in law, it's under the Maryland Healthcare Decisions Act. 5 wishes is not. That can be a very helpful tool in helping an agent understand what their family member wants, but it's not, it doesn't have the legal authority of an actual advanced healthcare directive or an advanced mental health care directive. So Maryland has a really nice part of the statute, and this is for situation health surrogates when, you know, God forbid you have not done an advanced healthcare directive, you haven't done an advanced mental health care directive. Maryland law allows for family members or close friends to become health surrogates. Next slide. So here are the individuals who can be health surrogates under Maryland law, and here's the priority. So top priority would be the patient's guardian, and you're saying to yourselves, why would you need a health surrogate if you had a guardian? It's because guardianship orders can be limited, and even though you may have a guardian, you may not have a guardian that covers the situation that's involved at that moment. Next in priorities, the spouse or domestic partner, an adult child, a parent, an adult sibling, or a friend or other relative subject to certain requirements. Next slide. So a friend can be a health surrogate if they're competent themselves and they state in an affidavit that they're a close friend and how they've known the patient and that they have maintained enough contact that they are familiar with the patient's activities, health, and personal beliefs. Next. So same situation, the health surrogate doesn't step in to make decisions until, just like with the advanced healthcare directives, 2 physicians say that the individual is incapable of making an informed decision. And yes, you will get the slides after this presentation. I just saw the chat box. Cool, I'm keeping up. Next slide. So a surrogate is supposed to make decisions that in their experience best represents the patient's wishes, and that may include knowledge of the patient's religious or moral beliefs and their expressed preferences with regard to withholding or providing treatment. Next. So there's some limitations on the health surrogate. Their decision regarding life-sustaining procedures can't be based on the patient's pre-existing long-term mental or physical disability or economic disadvantage. Next. A health surrogate cannot authorize sterilization or treatment for a mental disorder, and the healthcare provider can't withhold or withdraw life-sustaining procedures on the basis of an advanced directive where no agent has been appointed or on the basis of the authorization of a surrogate without special certifications. Next slide. Opal, you're doing a great job. Thank you, ma'am. So the other limit is, again, we're talking about withdrawing life-sustaining procedures or withholding them only if the patient's physician and a second physician certify that the patient is in a terminal condition or has an end-stage condition, or 2 physicians, one of whom is a neurologist, neurosurgeon, or other physician who has special expertise in understanding cognitive functioning, certifies that the patient's in a persistent vegetative state. Obviously, this is a protection because here, remember, this is a situation where there's no guardian and there are no advanced healthcare directives. So the law is trying to be protective under those circumstances. So I'm going to recap where we've been so far. We've talked about what's involved in informed consent. We've talked about the importance of preserving autonomy. We've talked about 3 of the possible less restrictive alternatives to guardianship. We talked about advanced healthcare directives. We talked about advanced mental health care directives, and we just talked about health surrogates. I'm going to pause for a moment before I move on to financial matters.
So there's a couple questions in here. The first one is specific to well, here's the question. We took our daughter, our over 18-year-old daughter, to Children's Hospital for a specialized test that required sedation. The anesthesiologist asked a number of questions of her and seemed to want her to answer every question perfectly. And so this person would like to know, is this typical?
So here's the dilemma, and that's a really insightful question. The dilemma is for healthcare providers that they have an affirmative legal obligation as well as an ethical obligation to make sure that their patients understand what it is they're proposing to do to them or not do to them. It is very hard for healthcare providers who don't know individuals with disabilities to have good communication. So if what I find is, and I have found this with my clients, I have clients, there's this incredible, another young woman with Down syndrome who, if she's comfortable with you, she'll tell you everything. She's got a job, she was working at a pizza shop, and she'll go on, she'll tell you the world. But if you don't know her and she doesn't know you and she's not comfortable with you, why is she going to open up and answer questions? So part of the problem, and what's the important insight from the question is your daughter shouldn't be precluded from providing informed consent or informed refusal simply because she can't answer every single question. So, and it may be that you as the parents, and we're going to be talking about supported decision-making a little bit later in this presentation, that your job would be to do some education of the healthcare provider to say, gosh, you are a total stranger. My daughter is like a deer in the headlights with you because she does not know who you are and why you're asking her all of these questions. Let's take a step back. Let me take a head at explaining this. I think that she does understand the basic concepts, but you're using vocabulary that is not going to work for her. And so, let me give you an example from my own law practice. I had an adult client, young woman with both a mental illness and an autism spectrum disorder. And the point that she came to me was to get services through the adult developmental disability system to help her because her parents were aging and had lots of medical issues and were not going to be able to have her living with them much longer. So to try to help her on a very emotional topic, I got her chatting with me and drawing pictures. So I got paper and different colored pencils and stuff. And we talked as she drew her life. And she drew this beautiful home. And we talked as she drew it with me. And so that I, by the time we were finished, felt that she understood what legal choices she had and that she could make an informed decision. Very few healthcare providers have the patience to really try to get, to make sure that patients understand or know how to break down complex medical lingo so that an individual who may not have that vocabulary can understand. So if you disagree with that healthcare provider, you can let him or her know that and say, gosh, can we do another approach to this, because we really want our daughter to participate in this process, and let's think through another way to approach this. It's hard for me because I can't see the family member's face to see whether I'm answering their question or not, but they can feel free to write in the chat box, and I can address this more later if this didn't cover what they were asking for. Because I do want, that's a very important question. So I'm going to move on now to talking about financial matters. So once you're 18, you magically get to, buy houses, buy cars, make financial transactions, do banking. You are presumed to be perfectly capable, even if you've never done it before. So power of attorney is a wonderful mechanism. And again, everybody should leave here tonight and create a power of attorney. I have one, and my husband is my agent to make all my financial decisions. Power of attorney, unless you specifically say so, it is going to go into effect immediately, meaning no one needs to determine whether or not you are capable of making whatever financial decision it is. So, for example, my husband used the power of attorney to sign all the paperwork involved in leasing a car for me. And, he could write my name, and he had all of that, and nobody had to determine why I didn't happen to come to that session to sign the leasing documents or whatever. So that's a good thing, because you don't really want banks to be saying, gosh, provide proof that person's incapable of doing banking. So anyone at any point can choose, anyone who's 18 years of age or older can designate an agent to make whatever healthcare decisions, financial decisions that they want them to make. It can be limited to one transaction, or it can be very broad. Now, one of the key points in the power of attorney is that you can designate who you would want to be your guardian if you ever needed it. And you can put that on the power of attorney document. Next slide. So typically when we work with families and we draft powers of attorney and we draft advanced healthcare directives, we typically include soup to nuts. We include, accessing bank accounts, buying real estate, entering into contracts, paying taxes. Back one, thanks. So there is a Maryland statutory form that we recommend using, but then there's a space that says any other directives, anything else that you want your agent to be able to do. And then we add in all the details of what you might want your financial agent to be able to do. And usually that's many pages long, because we want to cover every eventuality that we can possibly think of. So questions on powers of attorney? Okay, moving on. Oh, question about healthcare power of attorney. It isn't, if it's for healthcare, it should be called what it is in the law, which is an advanced healthcare. Some people use that terminology, but the term in the law is advanced healthcare directive. So powers of attorney in Maryland law deal with financial or property transactions, not healthcare decision-making. If you're going to do healthcare decision-making, you're going to use an advanced healthcare directive or an advanced mental health care directive. Okay. I want to talk with you about something that I'm a part of. There's a statewide coalition. We have funding from the Developmental Disabilities Council, and one of the things that we're looking at is the possibility of a new legislative proposal that would allow individuals to retain decision-making authority and choose a supported decision maker. Next slide. So this happens all the time. I mean, naturally, today, even without a statute, people use trusted friends and family members and professionals to help them make decisions all the time. I mean, when I go to the doctor, if it's anything important, I try to bring my husband because he's going to help me remember what the doctor said, but also then we can talk about it afterwards. With my family members who have disabilities, I've gone with them to meetings with healthcare providers or for the Developmental Disabilities Administration, for going to developmental disabilities meetings to talk about how the setting should be changed or whatever. And I'm not the agent or the guardian, I'm there as a family member. And I'm there to help my family member with a disability make decisions and understand what the choices are. So this could be, in Maryland, another alternative to guardianship that preserves decision-making authority, and then individuals get to choose who they want to support them and in their decision-making. Next slide. So supported decision-making legislation or resolutions have been introduced in 40 states and in the District of Columbia, passed in 19 states and in DC. There's 18 state grant programs, a number of jurisdictions. There's pilot programs in a number of different states. And what we're doing in our coalition is we're looking at the experience from all those different states and looking at what would be the best policy in Maryland. So just to recap, there is not yet a law in Maryland that talks about supported decision-making. There's one very small reference to it under organ transplantation, but that's an extremely limited way that Maryland law talks about supported decision-making. And the coalition is with members from all over the state, many different stakeholders, and we're looking at whether it would be appropriate to move forward with legislation in Maryland. Stay tuned. Next slide. Okay, yay, guardianship. So you can have a guardian of the person, you can have a guardian of the property, or you can have a guardian of the person and the property. The legal standards are different for the different guardianships. Also note that the language used in this statute is ancient and outdated because it talks about mental disability or disease. We don't usually talk that way anymore, but this is right out of the guardianship statute. So the court can grant the appointment of a guardian if the individual lacks sufficient understanding or capacity to make or communicate responsible decisions concerning his person due to any mental disability or disease. Now you're saying to yourselves, what is a responsible decision, right? How do we know? That's a pretty subjective term. Just like when we were talking about incapable of making an informed decision, what kind of decisions are people making? So it's an incredibly subjective standard, and I'm going to be talking about who makes that decision. So In addition, the court must find that there are no less restrictive means of ensuring that person's health and safety. So for most of this evening, we've been talking about what those less restrictive alternatives are. So when I'm drafting a petition to have a guardian appointed, I have to affirmatively assert that there are no less restrictive means of ensuring the individual's health or safety other than having a guardian appointed. Next. So here's the standard for the appointment of the guardian of the property. Again, incredibly subjective. Guardian can be appointed if an individual is found to be unable to manage property and affairs effectively. Now, how many of us know people who cannot handle balancing their checking account, right? How many of us think that we've got relatives or friends who spend money unwisely and not effectively? That's not what we're talking about with guardianship of the property. We're talking about an individual who really cannot manage property due to, again, this archaic, outdated language from the statute, any mental disability or disease, and has or may be entitled to property or benefits which require proper management. Next. So interested persons can file a request, a petition with the court asking that they be appointed the guardians of an individual with disability. Next. So the definition of interested person means the guardian, the heir of the minor disabled person, any governmental agency paying benefits to the minor or disabled person, or any person or agency eligible to serve as guardian of the person or of the disabled person. So lots of people have the right to file a petition. Lots of agencies have the right to file a petition for guardianship with a court. The question that I saw come up in the chat is, yes, you can have a guardian of the minor if under certain circumstances parents aren't available. So yes, that's possible, but I'm really focusing on guardianship of adults this evening. So what has to be filed in court along with the guardianship petition? You need 2 certificates from the legally required healthcare professionals stating that the person requires a guardian. Next slide. Who are those people who can certify that an individual needs a guardian? So keep in mind, here's the rule, at least one of those certificates has to be from a physician. And remember that psychiatrists are physicians. So it could be, you know, a psychiatrist, it could be 2 physicians, but at least one of the certifiers that the individual needs a guardian has to be a physician. The other certifier can be a psychologist or a certified clinical social worker. Next slide. So in 2017, the Maryland court system developed forms for each type of certifying professional to use, with different forms for physicians, psychologists, and social workers. And these forms have been required to accompany guardianship petitions as of 3 years ago, January 2018. Now, the reason we mention this is because there are lots of healthcare providers who have the old forms. They don't have the new forms. They're not going to work. They're going to get thrown out. They're not going to get accepted by the court. So at the end of this presentation, I have the link to the Maryland Judiciary website that has these forms on it. The forms are complicated. So anyway, I recommend sitting down with the person who's going to certify and go through the forms with them. Next slide, please. So at least one of the certifying professionals must have evaluated or examined the person within 21 days before the filing of the petition. Now, that may sound easy, but 21 days goes by really quickly, and healthcare providers are usually very busy. And, you know, you hit that 22nd day and the certificate is no longer any good. So at least one of the certificates has to be filled out within at least 21 days of the filing of the petition. I've seen a bunch of questions come up, so I want to pause for a moment. And Brooke, you want to share?
Sure. The first, I want to ask three and then one that was about something a little bit while back. How does one get a power of attorney? A power of attorney? Does this require assistance of an attorney and costs?
So there is a form in Maryland law that you could fill out without the assistance of an attorney. I think it's, I think you will get a better, more comprehensive result if you work with an attorney. It is not expensive to work with an attorney to effectuate a power of attorney. But the form I find wanting, meaning it doesn't cover everything that I would recommend be covered. But you could, it's there, and you could find the form and you could fill it out. I don't recommend it. Next.
Does a power of attorney have to use a limited time or be valid for more than a year? For example, does it have to be renewed every year?
The power of attorney remains in effect as forever until you rescind it. But just like advanced healthcare directives, I recommend that you take a look at your power of attorney on a regular basis so that you can make sure that you still want that person to be your agent. But it continues while you are alive.
Thank you. So the next question goes back to supported decision-making. Isn't there a community of practice in Maryland regarding supported decision-making? I believe that they use many of the life tools developed by the University of Missouri.
I'm familiar with the coalition, statewide coalition, and but I am not familiar with the particular practice that participant is describing. I think it sounds interesting. There are, at this point, because supported decision-making, you saw from my earlier slide, is being looked at all out, you know, throughout the United States. There are tons of resources. So I may have missed that resource because we've been gathering them, and I have not read every single resource that's out there for supported decision-making, which is why I included the link to the website with all the supported decision-making information on it in that slide. So if you would, if you look at that and click on it, you could find what's out there nationally in addition to what's available in Maryland. Part of this coalition is going to be doing exactly what this person is asking. We're going to be trying to develop a community. We're already doing that, and then provide education and resources to help everybody effectively use supported decision-making once it becomes a tool. As I mentioned, yes, people use it informally. I've used it with family and friends for years, for decades, because that's what friends and family do. They provide supported decision-making. But with the exception of organ transplantation, there is no Maryland statute governing supported decision-making at this time.
Great, thanks.
So one of the harder parts of guardianship is that the court will appoint an attorney to represent the, and forgive me for the terminology, but it's the way the law is written, for the alleged disabled person. Just like every other part of the law, there are lawyers who will be appointed who have deep understanding of individuals with disabilities and those that don't seem to. Sometimes this is a hard thing for parents to have an attorney appointed for their adult child because it makes them feel like this person thinks they're not trying to do the best. So in other words, you know, we represent parents who will file a petition for guardianship of their adult child. And then there is an attorney appointed for the adult child who then will meet with the adult child and meet with the parents and then make a recommendation to the court about whether or not it's appropriate for a guardian to be appointed. If we're involved, we, you know, talk with the attorneys that have been appointed, and, you know, we typically have a good, open, candid conversation with them about why we think a guardian needs to be appointed, and we help parents through the process. Next slide. So this is the only thing that I've talked about tonight that requires going to court. For a guardian to be appointed, there has to be a hearing. Typically, those hearings are just before one judge and there is not a jury, but there is the right to a jury trial in a guardianship case. None of my guardianship cases have ever gone to a jury trial. So it's a rare occurrence. Typically, the attorney for the alleged disabled person waives the right to the jury trial. The hearing is supposed to be closed and it's supposed to be confidential unless the court decides to hold the hearing as an open hearing for good cause shown. I see a question about what if the adult child requests that a guardian be appointed. And that's a situation, you know, in, you know, many situations because they want their parents to be the decision maker. So that would be something that the court would take into consideration, and absolutely the attorney for the alleged disabled person has to take into consideration the wishes of their client, the alleged disabled person. So yeah, that would be important. So moving on, the court or the jury will review the petition certificates and decide whether the person needs a guardian of the person or a guardian of the property. Next slide. So these revised Maryland rules that went into effect in 2018 set out training requirements for not only court-appointed attorneys for disabled persons, but also they set out training requirements for people who've been appointed to act as guardians. Next slide. So one of the things that parents ask me, especially when they have adult children who have very complex mental illnesses that they're having a hard time dealing with, they will say, well, look, if I'm the guardian for my adult child, can I have them involuntarily civilly committed to a mental hospital? The answer is no. That alone cannot be the basis for commitment of a disabled person to a psychiatric facility. Next. So the court can have appoint a guardian for just one healthcare, one surgery, one financial transaction. Typically, the guardianship orders that we're involved in, it's usually for both guardianship of the person and the property, and the guardian is given pretty global decision-making authority. Next slide. So this is something that people do not realize. Just because there's a guardian, in Maryland, this is straight out of the law, appointment of a guardian of the person is not evidence of incompetency of the disabled person and does not modify any civil right of the disabled person unless the court orders, including any civil service ranking, appointment, and rights relating to licensure, permit, privilege, or benefit under any law. So if you have a license to be a plumber or whatever, simply because you have a guardian doesn't mean you've lost that license. Next. Guardianship also does not take away your right to vote unless the court has specifically found that the individual cannot communicate with or without accommodations a desire to participate in the voting process. Next. Okay, questions before we get to the case study?
Yes. Do laws around guardianship vary from county to county, or are these state laws?
So that's a really easy one. It's a state law. So everywhere in Maryland, it's under the same law. And the court that I go to is the circuit court where the alleged disabled person resides. So I go to Baltimore County Circuit Court or, Anne Arundel County Circuit Court. And there are judges who understand guardianship who then handle those cases. Next.
Thank you. Let's see. Can guardianship be revoked now that more supportive tools seem to be available?
Absolutely, great question. So at any point that a less restrictive alternative would work for an individual who's got a guardian, hallelujah, yes, you can terminate the guardianship at any point. The other thing that I want people to know is that simply because you use the less restrictive alternatives to guardianship, that does not preclude your right to petition for guardianship later. And in fact, that may make the point that there is no less restrictive alternative available because you've tried the less restrictive alternatives and they weren't able to effectively protect your family member. I saw one about moving to another state. So if you're the guardian in Maryland and you move to Florida, what you're going to need to do is register that guardianship with whatever is the comparable circuit court in that state. Different states call courts different things, but it's registered there, and then usually the court will accept that guardianship without having to go through another one. I have had at least one situation where we did need to refile the petitions for an out-of-state guardianship where the family was moving into Maryland, had guardianship in a different state, and so we had to refile here in Maryland. So it shouldn't be that complicated, but it can be depending on the state and depending on what the guardianship order says from the other state. So Brooke, should I move on with the case study?
Yes, thank you.
Okay. So Mary Jones, she's now 18. She's been an active member of her community. She just graduated from high school, loved acting in school plays, She had an individualized education program, an IEP, during her time in school based on her intellectual disability. Next. Mary's parents are concerned about her ability to make healthcare decisions. They wonder whether they should have a guardian appointed. Her doctor says that she needs a guardian because she has Down syndrome. She still lives with her parents while she goes to a special programs for students with disabilities at the local community college. Next. Does Mary have capacity? What else do you need to know? Does she need a guardian? What are the ethical considerations and the possible solutions or next steps? So the answer to the question is, does Mary have capacity? We don't know. Just because she's got Down syndrome doesn't mean she can't make decisions. As you all know, one person with Down syndrome is one person with Down syndrome. They're highly unique, just like we all are. All of us have our different abilities. I can't see for nothing if I take my glasses off. You know, we each have our strengths. You know, if you're in doubt, get a second opinion from a mental health professional who has expertise in evaluating individuals with developmental disabilities. Not all healthcare providers understand individuals with Down syndrome or individuals with developmental disabilities. So you want to go to someone who specializes in those kinds of assessments. So if Mary's willing, she can execute a power of attorney, an advanced healthcare directive, which could make appointing a guardian of the person unnecessary. So I had, you know, one of my clients, a young woman with Down syndrome, the one who had the great job at the pizza shop, she absolutely knew who she wanted to have make decisions for her and was very clear and understood both power of attorney and the selection of an agent for the advanced healthcare directive. Next. Oh, is that your beautiful, wonderful? Oh, hey, welcome. Thank you for coming. Your mom is great. She's doing a wonderful job with my slides. I'm going to move on to the next case study, and we've just got a few minutes left. Lisa Adams, 21-year-old senior at a local university. She's doing great academically, been on the dance team. She's been diagnosed with bipolar disorder when she was in high school. She's generally been stable with medication, but has occasional setbacks that make it hard for her to study and work consistently. Next. So Lisa and her parents want to plan for the future. What is she going to need, right, after her parents have passed away? Next slide. Although Lisa has an emotional disability, she most likely will not need to have a guardian appointed on her behalf. Most individuals with emotional disabilities, and frankly, most individuals with disabilities, are capable of making informed decisions about who they would like as their agent for an advanced healthcare directive, and are fully capable of choosing a financial agent through a power of attorney. Next slide. Specifically, Lisa may benefit from executing an advanced healthcare directive, as well as a mental health, an advanced directive for mental health services, to designate somebody to make decisions for her, mental health care decisions for her when she can't make those decisions. And she can designate her preferred mental health providers and her preferred medications. Next slide. She can give her parents the power of attorney for financial and property transactions, and her parents could be appointed representative payees for any government benefits she may receive. Her parents could also establish a special needs trust on her behalf. And as I noted earlier, guardians don't have the authority to commit people to a psychiatric facility without an involuntary commitment proceeding. I think we may be done. Cool, and here's helpful forms. And I've got I can show you, this is my guardianship handbook, which I think has been posted for everybody. I'm working on updating it, but everything that's in it is good information. And I'll let you know when it's updated. Brooke, did you want to give me questions?
Sorry, I was uploading a resource page. So yeah, here's a question. What kind of authority would I need to, for example, call my daughter's medical insurance and ask why they didn't cover treatment X?
So the insurance company may want both the advanced healthcare directive and a power of attorney, since you're dealing with financial transactions as well as healthcare transactions. You need to check with the insurance company, but you know, the best approach would be to give them you know, both. I know recently we actually had to deal with this with a relative within the past couple of months, and we had to send, because we were questioning insurance, so we sent both the advanced healthcare directive. My husband was the agent for this individual, as well as the power of attorney, and then we were able to he was able to straighten out you know, the health insurance coverage. So my guess, but I don't know every insurance company, but my guess is they're going to require both. Next.
Ellen, does the information that you've presented tonight, I know it's specific to Maryland, but does it also relate to DC?
So the principles, you know, like the requirement for informed consent is a universal principle. That particular part of it comes from Maryland case law. So to be safe, I would connect with a DC attorney if there's specific questions, because there may be a nuance in DC that I'm not aware of. So that would be my recommendation. But, you know, there's guardianship in every state, and in DC, the actual language of the statute will probably be different. Maryland statute's pretty old and has got some pretty archaic language in it.
Thank you, Ellen. I'm just looking here to see if I've missed anything.
You're doing a great job too, Brooke.
Oh, thank you. I do want to just say that there was a comment made earlier, and here it is, that I don't know if everybody's reading the chat. And if you haven't, then I would recommend opening it at this point, because there are lots of links and there are files to download for resources, and including the slides that were presented this evening. So here's a comment. In our family, there were 3 age 18 rites of passages. So this person has 3 sons, and not only that, but there were 3 rites of passages. One was the right to vote, to register to vote. One is to sign up for the selective service because they're boys, and one was to go to the attorney's office to do medical directives, wills, and durable power of attorney documents. The power of attorney really paid off when our older son, without a disability, had a medical issue in Seattle, and we were able to get surgery-related records sent from DC to Seattle. And I just think that's especially because there's so many programs opened up that, you know, you never know if your kid, you know, with a developmental or intellectual disability might, you know, go off to college or go somewhere else and doesn't live with you, and you might need to do something like that. So Penny, thank you for that, insight. And here, let's see, there's a couple more things. Let's see, if a person with developmental disability lives in Maryland but travels to another state for a visit, will the other state accept a Maryland power of attorney and advance health care directive?
They should, because you're still a Maryland resident. And my experience is, and I've had recent experience with this, having a relative who just went through this in another state, everything that we did in Maryland was accepted. So, you know, if they don't accept it, your options are to try to challenge that. But my experience over many decades is that I had experience actually also many years ago in Florida, and everything was accepted. Recent experience involved Massachusetts, and everything from Maryland was accepted. So that's been my experience. But there could be, I am not an expert in all 50 states and the District of Columbia, so it's possible there could be some stupid state who does something differently, but that's not been my experience.
We do have a couple more minutes, so if somebody wanted to speak a question, you can unmute and ask your question.
So
I have a question. It's Liz Baldini. So in lieu of the state of Maryland not having the supported decision making yet, you are suggesting the advance directive and the power of attorney, correct?
absolutely.
Okay, thank you.
And
That's great.
Yeah, and it doesn't preclude your family member saying to a healthcare provider, I want my mother, my grandmother, my sister in the room with me for everything, because I want her to help me make decisions. So you don't have to have a law. I do that, as I said, you know, with my husband, because I'll say, you know, he helps me make good decisions. So even without a law, you can have a close friend or a relative with you to help you make decisions. And even something that we've done, even during this awful COVID time, and, you know, thank God we're all here together tonight, but I know people who've lost loved ones. But even during COVID, what we've done is to have our loved one on speakerphone with the doctor, so that we could participate and ask questions. Or, you know, we did conference calls. We found other ways to participate. So I know it's 8:30, and I just want to say, you know, I know how hard it is during this this past year. It's just been horrific for so many people, and I wish you the best. And you know where to find me if there's questions that come up after this meeting, and I'm happy to do so. And I just wish you and your families the very best, and thank you for allowing me to present.